What we know is a drop. What we don't know is the ocean.
Hello, and welcome to the Newton Knowledge Podcast. My name is Mark Singer, partner of Newton One Advisors, and I'm joined by our managing partner, Steve Target. The Newton Knowledge Podcast will provide meaningful content to our valued advisor community. Our discussions will deliver unique insights into the people, processes, and products that make our industry so critical. Newton One is a national life insurance planning firm delivering customized solutions structured to help clients and their advisors engaged in solving estate planning, wealth transfer, business succession, and executive benefits challenges. We are a member of the M Financial Group, which grants our clients access to the nation's elite carriers and exclusive products available only through our network.
I saw you have the whoop.
There we go.
Yeah.
I woke up in the green today.
Did you?
I did.
I was in the red. I went out. So it's so funny. Like the whoop, it totally tells you when you're screwing up.
Yeah.
Because like clockwork, if I go out, to dinner and even have a couple of drinks, I'm in the red.
Yeah.
The next
Eating
day.
a little bit later does it for me.
Yeah.
For sure. Like a pasta meal at 8 o'clock at night.
Yeah.
A couple glasses of red wine. I'm sunk.
You're sunk the next day. So yeah, I woke up in the red because we went out to dinner I only had a drink and a half, but I woke up in the red on Sunday. I'm in the yellow today.
Doesn't it mess with your head?
It does a little bit.
I feel defeated.
Because I woke up
Yeah.
green,
Yeah.
You're like,
green ready to go
better than
this
this.
morning, and I thought I was going to be in the yellow. I'm in the green. It's going to be a good day.
I think it's like a positive thing from a standpoint of like it does to a degree like reinforce good habits, but I'm also not using it. I know some people use it, well, I'm in the green today, like I'm going to go like super hard with my work. Like it doesn't change like what I do really, other than just being like, wish I was in the green every day.
Although I have backed off on workouts. I have backed off when I'm in the red or yellow.
Yeah.
Where it's like, yeah, maybe your body just, maybe today's the day to just take a little.
To take it a little easy.
And it'll give you that buzz, like the thing will buzz when you hit a certain.
Yeah. When you
like
for
you're
your day.
exceeding for your day. So I've definitely listened to that.
Yeah.
If I'm running or something, it's like, oh, you hit at 12 or 13%, and then I would stop. But yeah, when you're in the yellow or red, you just feel like, damn it.
You just feel defeated.
Better than that, yeah.
I shouldn't have done that.
This is the first time you've been here, right?
Yeah.
What was this building before?
So this building has had two iterations. So it was the original Bank of Delaware, and it was built in the 1700s and moved brick by brick from downtown Wilmington out here in like the 1800s, which is wild. So like if you go out downstairs, the front entrance, and you take the patio around, just below us, if you look up, you'll see the original bank entrance, and it has up there the date that it was built and then the date that it was moved
Wow.
out here, which is
I didn't
like
know
pretty
that.
wild.
Yeah.
And then
It's insane.
And then like if you look at the building to the left, you'll see the clear delineation of the 1950s edition. So it was the Bank of Delaware, but then when it moved out here, it became the Delaware Academy of Medicine. And so it's a historic building. The doctors, we are in their library. This used to be the medical library. We bought the building in 2001. And we moved in here, it was either the very end of 2003 or the beginning of 2004. And when we did that, the Academy of Medicine was still here, and they were leasing the space from us, but they were building their facility out by Christiana Hospital. And so we slowly took over. Now we're out of space here, unfortunately. But we've taken over the entire building, and when we refurbished this library here, we tried to keep it like with that feel, that feel that they had.
You certainly did that.
It's pretty cool.
Really
Was there a
neat.
vault? If it was a bank, was there an actual vault in the building?
There may have been, but no longer.
Oh, that's
Yeah.
a shame.
I know.
That vault down in the Ritz in Philadelphia.
Oh, yeah.
Is it super cool?
Yeah, because they made it into a bar. It's like a huge.
See, that's what we should have done.
That's why you're familiar with it, Steve.
Right.
I haven't been in that bar in a long time, but I am familiar with that one. Yeah.
Today, it's an honor to speak with Michael Gordon, director of the Wilmington law firm Gordon, Fournaris Mammarella. I have a mouthful in terms of your bio and everything, but I'll just hit on some of the key aspects. You received your Master's of Law and Taxation from the University of Villanova. You're a member of the Delaware and Maryland Bar Associations. You were the former chair of Estates and Trust section of the Delaware Bar Association as well. A fellow of the American College and Trust Estate Council. You frequently provide lectures, so at Heckerling a handful of times, as well as the Philadelphia Estate Planning Council, which is the topic that you just presented on that we're going to go through today, which is trust modernization for effective estate planning. To kick it off, understanding trust modernization, can you explain to our clients that may want to modernize their trusts what typical changes are often made and what they should be aware of in doing that process?
No, I'm happy to, and I appreciate you guys having me. First time I've been on a podcast, so very exciting. You know, the thing with the modernization and modification of trust that is so interesting to me in many respects is, as estate planning professionals, we're constantly telling our clients that it's important to create an irrevocable trust to achieve some type of goal that you're looking to do, right? So we tell our clients that in order to move this wealth out of your estate for federal gift and estate tax purposes, you got to create this irrevocable trust and you got to make a transfer into that irrevocable trust. We tell our clients that in order to engage in certain types of tax planning from an income standpoint, you got to create this irrevocable trust and you have to irrevocably transfer this asset into the irrevocable trust. And we tell our clients for asset protection purposes the same thing, right? You got to create this irrevocable trust. You have to move the assets into the irrevocable trust. It needs to be hands off in order to achieve the benefit that you're trying to achieve. But at the same time, so much of our time, is spent on modifying irrevocable trust. And it's kind of like an interesting philosophical debate that you have as an estate planning professional, whereas we preach the importance of irrevocable trust planning to do all of this stuff, but at the same time, we are spending half of our days modifying these irrevocable trusts. And like, part of me has sort of struggled with, how do those two things work together, or do they work together? And the more that I think about it, I do think they work together, because, you asked a good question, Mark, why do clients want to make these changes? Well, a client's creating an irrevocable trust because they're trying to do something, right? They're trying to achieve some type of goal, but life changes, circumstances change, and you want the ability to allow this thing to be a living, breathing vehicle that can adjust and change over the course of time. So with the enactment of the various statutes we'll talk about today and the ability to make all of these changes to the trust, I don't think that that's sort of counterintuitive with the planning. I do think that those things can work together and work well for clients. But as far as the reasons why clients are interested in doing it, it really comes down to three broad categories, right? So number one, changes to the beneficial provisions. The terms of this trust are no longer working for the family from a dispositive beneficial framework, and they want to make some changes. And I'll give you a couple of examples of that. So we often have scenarios where a trust is created for the benefit of a particular beneficiary and his or her descendants, and there comes a point in time in his or her life where they're receiving distributions from that trust that may be supplementing their lifestyle. So for example, like, assume my father had created a trust for my benefit, and it provides that during my lifetime, Steve, as the trustee, can make distributions to me in his discretion, and then upon my death, it terminates and just pays out to my two daughters. Maybe I retire. Now I'm in a situation where it would be nice to have an income stream from that trust. And so I approach Steve, and he says, okay, well, this makes sense. You're a beneficiary of the trust. We're going to start making these distributions to you on a quarterly, or annual basis. And I get used to receiving those distributions, right? They're part of my lifestyle. My wife and I are using those to do the things we want to do. And I have a real concern that if I predecease her, she's going to lose access to the funds, right? Because it's going to go to my daughters at that point in time. So sometimes there's a desire to do this from a beneficial standpoint. I would like to ensure that if I do predecease my wife, she can continue to enjoy the same lifestyle that we were enjoying before I died. That's an example of a beneficial change. Another one along those lines would, just going back to the fact pattern, the hypothetical trust. What if the terms of that trust say, as I mentioned, that when I die, it just pays out to my two daughters? And this trust has grown decently over the course of time, and I'm pretty concerned with the funds just being distributed outright and free of trust to my daughters. Number one, they'll be includable in their estates, but more importantly, what if they get into hot water with an occupation or whatever it may be, and they get a creditor issue, they get married? I'm worried about protecting those assets from potential creditor claims of my daughters. And unfortunately, a divorcing spouse can, for many of us, be our biggest creditor. So I want to ensure that the assets continue on for them in some way. Those are a couple examples of the changes we often make from a dispositive beneficial framework that clients are interested in. I'll just mention the two other ones that come up quite a bit. Administrative changes. This is a pretty broad category, but this is the majority of what we're doing pursuant to these modification techniques. Yes, I do have fact patterns where I'm altering the beneficial provisions of the trust, but what is way more common is having a scenario where you want to change the administrative provisions. So for example, how do trustees get removed and replaced? That's a big one. Maybe there's outdated provisions in the trust instrument and there's no clear mechanism providing for the removal and replacement of trustees. In my world here in Delaware, with the directed trust that we create all the time, there's a real desire to bifurcate or trifurcate traditional trustee responsibilities. And that's worth just spending a moment on. So in a traditional trust structure, if Steve's my trustee and he's making distributions to me and he's making investment decisions, well, he's really doing three things in his capacity as trustee. He's charged with three separate and distinct responsibilities. So number one, you, Steve, as trustee, make all investment decisions. We're going to buy this, sell that. Number two, you make all distribution decisions, how and when the beneficiaries actually get money out of the trust based on the standards contained in the trust agreement. And then finally, you're responsible for administration, so tax reporting, record keeping, things of that nature. And what modern drafting has allowed us to do is to trifurcate those traditional trustee responsibilities through the separation of these powers. It's called a directed trust, and they're super popular these days. And so lots of modern trusts make it very clear that you can have multiple players in the game, so to speak. You can have your trustee, and your trustee may just be responsible for administration. You can create this position of investment advisor. So Mark, you could be my investment advisor. You're not the trustee, but you're the fiduciary responsible for investment decisions, and you direct Steve what to do from an investment standpoint. I can have a third-party distribution advisor that tells Steve as trustee as to how and when the beneficiaries get money out of a trust. That is super popular these days, and a lot of the older instruments don't allow for that. So, yeah, please.
I'm still responsible as the trustee, even if Mark is hired as the investment advisor. Is there still a fiduciary responsibility that I accept as the trustee to make sure that Mark is in fact making the right recommendations, that we're following the structure of the trust as it was established?
Well, that's a great question, and that's the beauty of the structure. So it depends on under which directed trust framework and law you're operating, but under the Uniform Directed Trust Act, which is recently enacted in Pennsylvania, and under the Delaware model that we have in place, it is a pure separation of responsibility. So even though you are the trustee and Mark is the fiduciary investment advisor, you don't have to look over his shoulder. You don't have to make a judgment as to whether or not he is doing what he's supposed to do under the terms of a trust. You don't have to say, Steve, well, I would have never made this investment decision if I were the fiduciary charged with that. It is a pure separation of responsibility, no duty to warn or apprise the beneficiaries in a scenario where you would have done something different. It's a very powerful tool, and it makes trustees feel way better about it because it's different than delegation. Yeah. Like if you were delegating that responsibility to Mark, you'd have to make a judgment about whether or not he was doing a good job.
Right.
Whereas you don't have to do that in the context of the directed trust.
What do you mean? Go ahead.
If we go back to that first scenario as well, if the trust is established so you as the beneficiary are receiving distributions, and perhaps the trust is stipulates that if you pass away, then your wife doesn't receive any of the proceeds, that those proceeds go, or the trust assets go to your daughters.
Yes.
As the insurance guys in the room, could there be an insurance policy placed on your life that would then compensate your wife for the loss of that trust asset if you were to die?
Absolutely. And that is the traditional way that you solve for that problem because, although there is a path forward to modifying this hypothetical irrevocable trust to allow my wife to continue to benefit from it, there are some tax issues that we're going to talk about that you have to be cognizant of when you modify it. So the safer thing to do would be for me to use some of that income stream that's coming out of the trust to purchase a life insurance policy on my life. And if I'm worried about estate tax issues, of course, that would be housed through an irrevocable life insurance trust. But that's like the traditional way you would do it, Steve.
Yeah.
And in many respects, it's the simpler way to do it. But you maybe have some issues where that's not feasible. The beneficiary is actually using all the money that they're getting from the trust, or maybe they're uninsurable. Yeah. And so there are ways that you can modify the dispositive provisions of the trust to give that access to the spouse. But life insurance is a great idea.
Some of these modernizations, you said some of the older structures don't allow for it. Why so, and how so?
So the way that old school sort of drafting, and I shouldn't say old school, there's some attorneys that still do it this way, but a couple of things. So first, within the context of this directed trust conversation that we've been having, that has really exploded in popularity over the past 15 years.
So it's relatively new.
Relatively new. So before that, you would just have a single trustee. The single trustee would be charged with all facets of the administration. Maybe the family would have the ability to remove and replace that trustee, but you really didn't have this clear path forward as far as the bifurcation or trifurcation of traditional trustee responsibilities. And the other thing, Mark, that you'll see is that in a lot of the very old trusts, there was no mechanism for succession of trustees. You'll see these old documents that appoint some, historic Pennsylvania bank as the trustee, either pursuant to the terms of the inter vivos trust agreement or the last will and testament, and that's it. There's nothing in there about changing the trustee. And so that can be an unfortunate situation too, because now the beneficiaries feel somewhat beholden to the trustee. They don't have any say in what happens. And so modern drafting doesn't do that. Modern drafting tries to create certain elements of flexibility, and at the very least, giving the beneficiary some say-so in who the fiduciaries are.
Some of the trusts your team is advising on span generations.
That's right.
Is that correct? So are you able to utilize this new modernization approach to those older trusts that are structured that's come to fruition over the last 15 years? Are they kind of grandfathered into?
It's a great question. So there's two things that you see practically. So number one, as far as these modernization and modification techniques, there's the statutory framework that we'll talk about. And then there's what you tend to include in the newer instruments. So for example, in the new trust agreements that we draft for clients, we normally have a built-in modification power within the trust. And so we give some power holder, whether it's the trustee or a trust protector or someone along those lines, the ability to make changes to the trust. And sometimes we say that those changes have to be administrative in nature. Sometimes we say, while the grantor is living and after giving the appropriate notice, you can change whatever you want, trust protector. And so it allows you to do this in a more streamlined fashion because you don't have to play within the parameters of any of the statutes. But to answer your question, even for those older trusts, what we're doing in those scenarios is we're utilizing the modification techniques like the decantings and the non-judicial settlement agreements and modification agreements. So those techniques and statutes are available to all trusts whenever created. So you don't have to worry, for example, Mark, that, my non-judicial settlement agreement statute was not enacted until after the date that this trust was created, so we can't use it. It's applicable to any trust whenever created.
Makes sense. Can you elaborate on the non-judicial settlement agreements that you utilize as a strategy for your clients?
Yeah, so this is a really powerful technique that we use, and there's two sort of versions of it, and it comes from the Uniform Trust Code, and then we have nuances here in Delaware. But the two statutes that we use all the time are the Modification Agreement statute and the Non-Judicial Settlement Agreement statute. So let me kind of explain how those two statutes work and the differences between them. So first I'll start with the Modification Agreement statute, and this comes from Section 411 of the Uniform Trust Code. And what it basically says is that as long as your grantor, settlor, synonymous terms, as long as they are alive, the grantor and the beneficiaries can enter into this modification agreement with respect to the trust and do whatever they want, even if doing so violates a material purpose of the trust, right? And that's kind of logical if you think about it in a way, because you're saying is this statute's only applicable while you're settlor is alive. And if the settlor is on board with these changes and all of the beneficiaries can be represented and bound and they participate, why should you not be able to make some meaningful changes to the trust? That's the first section or technique that we use. Now, we enacted this in Delaware too, so we're not a uniform trust code state in Delaware, but we've borrowed a lot of provisions from the Uniform Trust Code, and this is one of them. So we have a statute, it's called Modification of Trust by Consent. The trustor is living, and it's kind of like a souped-up version of Section 411 of the Uniform Trust Code, and it says, again, while your settlor is living, as long as all of the beneficiaries, and again, it has to be all of the beneficiaries, so your current beneficiaries, the remainder beneficiaries, the contingent remainder beneficiaries, they all have to be bound in some way. Now, the difference that we have with the Delaware statute versus what you see in Pennsylvania in the Uniform Trust Code is that under our statute, all of the power holders have to participate too, right? So we need to get the trustee to sign off. If we have an investment advisor, they have to sign off. If we have a trust protector, they have to sign off. Everybody has to come to the table and participate in this agreement, so to speak. But it was sort of funny, like when we enacted the modification agreement statute here in Delaware, which was not that long. I mean, I lose track of time, so it was probably a while ago, but it wasn't that long ago. My initial reaction was like, well, how often are we going to use this? Like how often are you going to have a scenario where you have a living settlor that created a trust not that long ago, and now the family's coming to you and say, well, we did this thing like 10 years ago, and we want to make changes to it. But the answer to that, it happens every day. I mean, it amazes me how many times I create this trust 5, 10, 15 years ago. Now, again, I'm trying to include these modern modification techniques within the document itself, so I don't even have to use the statute. But I still have tons on the books, where I can't do that. So we use this statute all the time to make meaningful changes. Now, again, there's some tax issues that we need to talk about, but that's the one statute. The companion to that is called the Non-Judicial Settlement Agreement statute. That's Section 111 of the Uniform Trust Code. Again, we have a slightly different version here in Delaware. But let me just explain like the main difference between the non-judicial settlement agreement statute and the modification agreement statute. First is that the modification agreement statute, again, is only available while the settlor is living. So if your settlor is no longer living, you got to look for a different technique to modify the trust. The non-judicial settlement agreement statute is available regardless of whether the settlor is living. And it says that the interested parties, so the beneficiaries, power holders, fiduciaries, can enter into this non-judicial settlement agreement with respect to any matter involving a trust. But here's the key language. You cannot violate a material purpose of the trust pursuant to the non-judicial settlement agreement statute. So it's like...
Is material purpose clear? Or
well,
sometimes,
right.
What becomes a material purpose?
Well, that's the exact problem, because it's not. And like there are some comments in the Uniform Trust Code that speak to it a little bit, and there's case law in different jurisdictions. I mean, and there's some things that the three of us could probably look at and tell you this probably violates a material purpose, but there's other things that are just sort of nebulous. I'll give you a good example. This whole concept of me trying to benefit my wife from this trust of which she is not a beneficiary, well, doing that, trying to either grant me a power of appointment that I could exercise to appoint the assets to her, or actually naming her as a beneficiary of a trust, that is clearly a material purpose. Whoever created this trust did not intend for my wife to be a beneficiary of a trust. What's more difficult is, what if the terms of the trust say that at all times you have to have a corporate trustee? And the family says, it's kind of expensive, I don't really want to work with a corporate trustee. Could we instead modify this trust to allow for an individual trustee? Well, what did the settlor mean when he or she created the trust? Was it really important to them?
What were the circumstances at that time?
Right.
Yeah.
And so that is a tougher one.
That's hard. How do you know?
That's why any time that I am sort of touching anything that I think could be a material purpose, I don't use this technique. And to be quite candid, when you look at the sort of options on the table that you have for modifying and modernizing these trusts, non-judicial settlement agreements tend to be my last go-to, just because I don't know whether I'm violating a material purpose. So they can be very helpful, but depending on what you want to do, you may need to look to a different technique.
Should we start talking about decanting?
Yeah.
When and how and where do you use decanting?
So decanting, people love this concept, right? So decanting, when you think about decanting, what do most people think about? Wine, right? So the word decant means to pour liquid from one vessel to another, like, pouring the wine out of the wine bottle into the decanter. And in the trust context, the liquid is the trust assets and the vessels are the trust instruments. And this whole concept of decanting really comes from the common law. In the idea that if, again, Steve, going back to this hypothetical trust that's been created for my benefit, if you're the trustee and you have the ability to distribute trust principal to me, instead of you just giving me the money outright, distributing it outright, why can't you appoint or decant the assets in further trust for my benefit? I mean, and at its like sort of baseline, most simple explanation and format, that's all a decanting is. Instead of me as trustee or Steve as trustee giving me money, Steve is giving me money in further trust. He is decanting the assets from one trust into another trust. Conceptually, that makes sense. If I could give you the assets, why can't I give them to you in further trust? And there are some cases. I mean, the big one is the Phipps case, which is the Bessemer family from probably like the 1930s or 40s. It was a Florida decision that said under the common law of Florida and certain other jurisdictions, if you had this ability to distribute trust principal to a beneficiary, you can appoint in further trust. New York became the first state to specifically enact a state decanting statute that codified this concept. That was in 1992, and we are probably up to, 30 states that have some form of it. And they all differ slightly in their application. There's a Uniform Decanting Act too, but they all differ slightly in their application, but they operate off of this sort of fundamental premise that if you can make a distribution to a beneficiary outright, you ought to be able to appoint the assets to them in further trust. But we utilize decantings all the time. It is really the go-to in many respects for modifying trusts.
So in the beginning you said, all of this planning is to accomplish something.
Yes.
And by making these changes, there could be some tax consequences. So what sort of planning recommendations do you have when you're structuring these to not, or making changes, to not have any maybe unintended tax consequences?
Right. Well, and that's like a really good question, because one of the things that's sort of wild about these various modification techniques is that I get called all the time by clients and they say, hey, Michael, we want to make these changes. We want to do, fill in the blank with respect to whatever it is. This trust isn't working for us anymore. We need you to help us figure out how to do whatever it may be. Change the beneficial provisions, change the administrative provisions. And I can probably count on one hand the number of times that I've had to go back to these clients and say, I have no path forward. I cannot figure out how to do what you want me to do. There's always a way that I can do it. Now, I may need to connect some dots here. I may need to take some various steps. There may be fiduciary risk associated with it. But the big thing is there may be tax risk associated with it. So whenever you are modifying a trust, whether it's pursuant to a decanting, whether it's pursuant to a modification agreement, whether it's pursuant to a non-judicial settlement agreement, you have to be cognizant of the potential tax issues. And there are really three potential tax issues to be aware of. Number one is, are there any generation skipping transfer tax issues to be aware of? Am I doing something pursuant to this modification that could result in loss of GST exempt status? Because you had talked, Mark, about the long-term nature of these trusts. I mean, many of clients are creating these dynastic trusts or these long-term trusts in jurisdictions that have either abolished the rule against perpetuities or allow for super long trust. And so they're allocating generation skipping transfer tax exemption. They want to ensure that the trust can continue on and benefit multiple generations. So you want to make darn sure that you're not doing anything pursuant to the modification that's going to cause a problem from a GST standpoint. Estate tax issues, if your grantor is alive and he or she is participating or involved, you just have to be sure that there's no estate tax issues. That's the easier one. The big one that's like this huge buzz right now is the gift tax ramifications. And the reason that is a big buzz is at the end of 2023, the IRS issued this CCA. So a CCA is a chief counsel opinion. It is sort of the litigation position of the IRS. It's not binding authority, but it says, here's how we view this particular fact pattern and what we would argue if we were litigating this. And the CCA involved a trust that was modified. And the trust was modified. It was a grantor trust. So basically the grantor dad was picking up the income tax liability on his personal return. And they went into court to modify the trust to include something called a tax reimbursement clause. So a tax reimbursement clause is lots of lawyers who draft grantor trusts give the independent trustee, so Steve, you as the trustee of his trust, the ability to reimburse the grantor for the income tax liability. It's a super helpful tool to have. And there's a revenue ruling from 2004 that says, excuse me, if the grantor has the ability to be reimbursed for the income tax liability, it doesn't cause estate tax inclusion. So it's very helpful to have. And in some states like Delaware, we have a statute that says any grantor trust administered in the state, there's this discretionary power in the independent fiduciary to reimburse the grantor. Well, the trust at issue in the CCA didn't have that provision in it. And it was being administered in a jurisdiction that didn't have a statute saying that it's inherently built in just based on the structure. So they went to court and they asked the court to modify the trust to include a tax reimbursement clause. As part of that, the beneficiaries, I think there was like one current beneficiary and then two remainders. The current beneficiary had to sign off. Excuse me. The current beneficiary had to sign off, had to consent to the modification. And as a result of that, the IRS in this CCA took the position that by virtue of the beneficiary consenting to this modification that would allow the trustee to reimburse dad, they had made a gift. They were giving up something, right? And like the theory behind it is that, well, I'm a beneficiary of this trust. I could receive discretionary distributions. If I consent to something that would allow that money to possibly go elsewhere, is my interest being diminished in some fashion? Am I giving something up? Now, the IRS, of course, did not say how the heck they would value that gift or what you're giving up precisely, but it really scared people as far as the use of these modification techniques. So, your question was, well, like, what do we do? Or when we're looking at these modification techniques, what do we do? The very first thing that we do is we look at what the family is asking and we make a decision about, is this going to have an impact on beneficial interest? Is there a potential diminishment of beneficial interest that could result by virtue of this modification? If the answer is yes, we got to think about how to mitigate that potential gift tax consequence or ramification to the beneficiary. And the technique that we pick is sort of focused on avoiding that. So going back to the modification agreement. Well, as I mentioned, in order for a modification to be valid under the modification agreement, the beneficiary has to participate. That's kind of similar to the CCA, right? Like if you are required to sign off on this modification that could have a potential should be reduction or diminishment of your beneficial interest, more likely the IRS would argue you made a gift. But what about a decanting? A decanting is an exercise of discretion by the trustee. It doesn't require beneficiary participation. In certain places like Delaware, you don't even have to tell the beneficiary about the decanting. That would be not a good call on the trustee's behalf not to tell the beneficiary about the decanting because of fiduciary risk. But from a tax standpoint, that's pretty good. So going back to like the example, if I wanted to benefit my wife when I die, I wanted to ensure that she was able to continue to benefit from this trust that's created for me. The way that I would do it, if I were the one drafting the documents, is I would utilize the decanting statute. I would decant into a trust that grants me this testamentary limited power of appointment that says I have the ability to decide where the money goes in some fashion when I die. And I would not have my daughters as the remainder beneficiaries participate. Because who is potentially making a gift there? Well, it would be my daughters, right? They would potentially be making a gift. They're the one that has this potential diminishment in beneficial interest. So the technique that we utilize is sort of dependent on the tax goal that we're trying to achieve.
Interesting.
We got a lighthearted question for you.
Yeah.
Trust planning aside. If you had to eat only one dish for the rest of your life, what would it be and why?
Yeah. Well, this is somewhat easy for me, Mark, because I am a creature of habit. I like to do the same thing at the same time every single day, right? And so I'm going to have to go with my staple every night. It's a New York strip for dinner, nothing else, no sides. So if I had to choose one thing to eat for the remainder of my lifetime, it would be that New York strip, medium.
I love it. I can't disagree with that. How does your Whoop respond with that? Can you tell based on it? Does it keep you in the green when you eat that, or is it?
It seems to like that. What it does not like is the alcohol or any sugar at night. You know, besides that, I think it's fine with steak.
This was great. Thank you for your time, and for this being your first podcast, you knocked it out of the park. So,
yeah, thanks.
yeah,
I appreciate you guys having
beautiful.
me.
Michael Gordon, Gordon Fournaris, and Mammarella. Thanks, Mike.
Thank you.
Bye. Goodbye.
The material and opinions voiced are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine what is appropriate for you, please contact a member of our team.